possible, Mrs. Wright, that he just wants to spend time with his children?
And as long as it's inconvenient for me.
Did he tell you that he wanted to be inconvenient for you?
He didn't have to.
It brings us to court. It can bring us to blows, with all of the drama of a daytime soap. But divorce is real life, and it's next on Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
Some 50,000 of us file each year. It can cost us our savings, it can cost us our peace. It's an area of law that we may know well if, like hundreds of thousands of our neighbors in New Jersey, we've had first-hand dealings with divorce. And since the system satisfies almost no one, it's no surprise that reform is on the drawing board, not only in the State House, but at the state Supreme Court, too. But what direction divorce reform should take is still a subject in contention, as we'll see when a past chair of the State Bar's Family Law Section and the current chair face off. But first, for a glimpse inside divorce court, here's Sandy King.
Raymond, a couple of weeks ago, we looked at deadbeat dads, and we went inside an Essex court to see what happens to them. But the child support wars often start in an earlier court action. Label it DIV-ORCE.
We're here this morning to proceed with the divorce trial between Mr. and Mrs. Wright. I understand we're going a little bit out of turn. Is Mrs. Wright first going to be called to the stand? Yes, sir.
The judge is real. The attorneys are too. What's not real is this case, or this witness.
Would you please state your full name for the record and your address?
Elizabeth Wright, 55, right-of-way, Jersey City, New Jersey.
With cameras barred from divorce courts here in New Jersey, this is as close as we can come to the real thing. A mock trial mounted not for our cameras, but for other matrimonial lawyers, to show them how it's done, from the direct examination of the wife.
What is your normal schedule with the children?
Well, after I wake them up in the morning, I fix their breakfast.
To the cross by the husband's attorney.
You don't want to share custodial time equally with Mr. Wright, do you?
No, no.
Is the reason because you don't want to lose authority and control?
No, the reason is because I want what's best for my children.
Now, in this divorce case, as in most where there are kids, and even the smallest amount of money, the fight is over custody and cash. So while her lawyer tries to show that she's just a loving mother...
Now, Mrs. Wright, you're not trying to keep the children from your husband, are you?
No, no, absolutely not. I just want what's in their best interest.
His side's out to paint her as a bitter, controlling woman, out not just for custody, but alimony, too.
Have you taken any steps to supplement your income since you and your husband separated?
I don't know what you mean by that.
Have you done any work other than your part-time work at your father's company?
No.
It's a rare litigant who doesn't hate the other lawyer and blame the other lawyer for everything that's wrong in their life.
These are, after all, adversarial proceedings.
With regard to custody, I wanted her to appear controlling and manipulative.
That's what some critics say is the source of the problem.
How nasty do these things tend to get?
Very nasty and very difficult. Most difficult is when you have children involved.
The worst thing that I have to decide on a daily basis is who gets the kids.
In this case, there are two, and their unseen father. Now, in a real case, he would, of course, have been in the courtroom. But in this hypothetical, he, like his wife, is fighting hard for custody.
The children become sometimes pawns in the matrimonial dispute. They're used to offset other things regarding like alimony provisions, and there are, they are certain times they are forgotten about as children, but they're just more or less used as pawns.
In this hypothetical, do you think that was happening?
Absolutely. Did you think it was happening? I thought it was happening. And it happens all the time.
Are you willing to go back working full-time sometime in the future?
Oh, sure. I mean, once our kids have graduated from high school. My main concern is our kids' well-being.
But Dr. Burr, a court-appointed psychologist, isn't here to push the interests of either side. And neither side is happy with his custody plan, with testimony that at times boosts the wife.
The children should have a primary domicile, and that this domicile should be with the mother.
And at others, helps the husband.
Mrs. Wright's plan to limit the presence of the father in these children's lives would potentially be damaging to these children.
But in a real case, if the parties could afford them, both sides would have expert witnesses of their own.
With Dr. Burr, we would each have our own expert in this case, considering hopefully if our clients had enough money for each of them to have their own experts, we would each have our own expert.
We were leading towards getting more alimony by saying she's unable to make more money.
But had the trial gone on, we might have been able to tie those issues a little bit more together and suggest that Mrs. Wright's custody demand is based on, or her employability problem are so related that she's not well motivated in either one. She's just using one as a crutch for the other, and in fact, you know, they could have joint custody, and in fact, she could work full-time. You know, that would be what I would try to do through other witnesses.
And since divorce court has no juries, just how does a judge manage to make the right call?
I can see the people who are testifying, I can hear other witnesses, and then I have an expert. It gives me a whole field of information to pull from. When people just come up and say, I want the kids, nothing else, it's an awful call. I can't tell in 5, 10, 20 minutes who's the best parent. It's impossible.
And when kids are at stake, it is far more complicated, but divorce is almost never simple. So the changes we could see in '97 range from forced mediation for all divorce to garnishing wages to get unpaid alimony. But the one that may appeal the most to anyone anxious to get a divorce, a bill now before the Senate that would shorten the required separation pre-divorce, Raymond, from 18 months to 3 months.
Does speeding up the process have a downside, too? Is adversarial always the way? Just a couple of the questions we'll put on the table when two leaders of New Jersey's matrimonial bar show it's not just divorcing couples who disagree.
I think divorce is a tough issue. I think it's a moral issue, not a legal issue.
It's sad of what happens because the children usually are the ones that suffer.
Female walks away with more than the male do.
Women have a harder time.
A lot of the time, the husband gets away with more than he should.
By the time they get a divorce, she doesn't know what to do. She doesn't know how to make any money.
Why should the man have to pay all his life?
Real victim of circumstances dealing with children.
People are going to be like at each other's throat. By all means, get away from each other.
Oh, I don't think either one makes out any better. They both fail.
So is there a way to cut down on the conflict and the time and the cost of divorce? For some answers, we turn to Edward Snyder, a former chair of the State Bar's Family Law Section, and Pat Barbarito, the section's current chair. Ed, let me start with you. I understand you're a critic of the current system. You don't think it works.
Yes, Ray. I don't think it works in general. There are some counties in which it works, but it's much too long, and because the system takes too long, it becomes more adversarial, and then it becomes more costly.
Why does it take too long?
Something has to be done. We don't have the judicial manpower or woman power to handle these cases. Some counties it takes 4 years from the date of filing a complaint to get heard in court. We have to find alternate methods of resolution.
Pat, you're the brains behind a whole bunch of legislation that's pending in the state legislature. Is that going to change?
Well, that's a kind compliment, first of all, but we'd like to see a change. First of all, I don't think that the system is broken. I think the system, an adversarial system, works. I think, like everything, it needs some fine-tuning. Yes, it takes long, and perhaps it could be shortened, but we need some systemic changes in a system that I believe already works. The adversarial system, we haven't come up with anything else that works better, Ray.
Well, let me deal with time first.
Sure.
What what can be done and is pending in the legislature to make it go quickly? Because time is money to the average person, isn't it?
Yeah, I think that the legislation that's pending is really secondary to the time. I think that the changes you're going to see come are from the Supreme Court Special Committee on Matrimonial Litigation recommendations. And we're hoping to see changes recommended such as active case management, a judge taking control of the case, managing it at regular intervals. We're hoping to see things like one judge assigned to one case, in control of a case. Those systemic changes will hopefully lead to a quicker resolution. And faster always isn't better. When we say that, no. Faster is always not better, Ed.
Hopefully, case management, that's one of the hot things that people are talking about now. But case management doesn't work unless you can promise somebody a trial date. And if you have case management and you require the attorneys to get their job done and get their discovery done within a certain date, and you say, we're going to go to trial in March, and that's a fiction, then you're going to have to case manage it again and again and again.
Are you saying under the current system there's effectively no way to realistically shorten the time from the beginning of the process to the end?
Well, there are ways to do it.
How would you do it?
Okay, first of all, domestic violence is bogging down our court system. Don't get me wrong, domestic violence, we have one of the best domestic violence acts in the country, and it's working. But you don't need judges to grant TROs. You don't need judges to grant final restraining orders. You can take that out of the courts, and you could put hearing officers. You could hire attorneys to serve
That
as
is in the attack position.
Yes, because I'll tell you, if I was going to be kicked out of my home, or somebody was going to make a decision on my life based upon domestic violence, I'd want a judge up there. That's what I'd want. I'd want my client to have a judge up there.
Pat, it's not that complicated a situation. Domestic violence is not that complicated. You've got to start taking some, I don't want to use the word routine for domestic violence.
Would you use referees or some person less than a judge to handle it?
Yes.
All right. In addition to that, what would you do to shorten the process other than taking domestic violence out of those courts?
I think we have to look at things like mandatory mediation. I think we have to look at things like binding arbitration. In California, they have something which they euphemistically refer to as rent-a-judge. It's private judging where you can go to, and it's enabled by statute, you can go to a judge who's retired. You can pay him, and he will handle, or she will handle your case. And some people say it's elitist, but at least it'll take the big cases, the cases that could potentially bog down the system out of the courts. Those are three ways.
Pat, sounds like
I'm not opposed to alternate dispute resolution, Ray, but the reality is to have mandatory mediation makes people do a couple of things. One, pay for an extra person. So now you pay two lawyers.
First, let's describe what it is we're talking about. You're talking about a system where everybody would have to go to another person, a judge or some other qualified person, and try to work out differences?
Well, it wouldn't be a judge. It would be a trained mediator. It would be somebody, mediation for people who don't know what it is, who are watching this program, is somebody who's trained in helping two people resolve their differences. That person is not going to make a decision. It's not arbitration. That's arbitration.
Is it something you might do?
No, I've looked into that, and I do not have.
But what you believe is necessary is that be required in every case, that people at least take a shot at that.
Well, not every case, Ray. I would not recommend it, for example, where there was a domestic violence restraining order.
In most cases, you would make it mandatory.
Yes, I would.
And Pat, I gather that's where you get off the boat?
Again, my opposition is to mandatory mediation, particularly economic.
Why?
I think mediation works well with custody situations because generally the financially unsophisticated or uninformed person is going to be compromised. A mediator is trained to do one thing: bring people to a middle. They're not supposed to give advice, let people know what their rights are. The person who is financially unsophisticated or is feeling guilty or is not emotionally prepared to fight is going to fold.
What Pat isn't saying, Ray, is that you don't go into mediation naked without an attorney. The mediation system works where you each have your attorney. They don't attend the mediation sessions with you, but the attorneys have to be committed to mediation, and you consult with your attorneys in between those mediation sessions.
As Ed said, the attorney's there to protect the person. What's wrong with that? And isn't that a way of helping many litigants save a lot of money?
In some cases it is, and in some cases, Ray, it triples the fee because you pay a mediator. Our judges are paid by our system. They are not paid by the litigants. So my question is, when somebody is running up legal fees in two separate areas, why pay a person that we have judges to do the job?
Is Pat right in saying this will effectively triple the fees for many people?
I don't think so. I think that it has the potential to lessen the fees. Yes, in some cases, mediation, and more than some cases, mediation will not work. But let's give it a try. The system, the way it is not working. Something has to be done to say, well, I'm in favor of mediation, but you know, only if they agree to it. Nobody's going to agree to it. We have mediation now, mandatory in custody matters. It's working. It'll work. It'll at least improve the situation in financial matters.
If people could settle their differences so easily, they wouldn't be getting divorced. If you have two competent, well-trained matrimonial lawyers, there is no reason that those people couldn't settle a case as well as with the assistance of a mediator.
Well, are there cases where the adversary system causes people who might be able to work things out to become at odds, spend more money, become more angry? Does that happen?
Yes, of course that happens.
Would mandatory mediation of the kind Ed's talking about solve those problems?
Mediation may address those problems, but to have it mandatory, again, is inappropriate in most situations because of the pressure on the financially less sophisticated, the more emotionally burdened person. It's entirely inappropriate. I think that, again, you know, if people weren't not getting along, they wouldn't be getting a divorce. Mediation assumes we're going to all come to one big happy middle. Well, it's not that simple. It's much more complex.
Can you, to put this in concrete terms for viewers, can you give us, because you've talked about this really as a cost and time-saving measure, can you give us an example in dollars of how much, what are the kinds of dollars people might save, and also what time might be saved by this kind of process?
Well, the time in a county, I won't mention any county because I don't want to embarrass any judges, but it could be 4 years to get divorced. If you can start your mediation process right away, I gather that in the typical garden variety case, you would know within 3 months whether that matter is going to be settled. And I don't know what mediators are charging now.
You might cut time in half?
Incredible time.
Right. What about costs in dollar terms for people who can afford it? What are the kinds of hourly rates that matrimonial attorneys are charging?
Anywhere from $150 an hour to $350 an hour, depending on expertise.
Over the course of 4 years, that can sound like an awful lot of money.
And it is an awful lot of money sometimes, and that's not right. But again, if you had active case management, judges who are controlling cases, lawyers who are controlling cases, and better yet, litigants who are controlling the cases by not letting their emotions be involved, then perhaps the time would be shortened.
You keep using the term case management. Every time you say it, it sighs deeply.
Well,
what does it mean, and why does there seem to be a difference about whether that's going to solve the problem?
I like case management. I think case management is important. I think judges ought to be controlled. What does it mean? I'm sorry.
Does that mean somebody's managing the cases now, right?
Well, in theory somebody is, but I think that what we're talking about from the State Bar position is to be more active, more in control, to say to people, okay, this Monday you'll be here, we're going to talk about where you are in your discovery process, and in 2 months I want to make sure X, Y,
aggressive in moving the process
and
forward.
the attorneys, because the reality is human nature is that litigants and lawyers sometimes don't focus on a case until they have a deadline. That's the way lawyers work. That's the way human nature is.
Pat, what about a county where they have active case management and they can't give you a trial date? Well, aren't you going to case manage it and case manage it and case manage it?
I don't think that
what good is case management
I don't
in
think
that
that case management can be done by itself. I think you have to look at the other issues that we're addressing. One case, one judge. I mean, there's got to be much more active intervention by the system, and the lawyers and the litigants have to take responsibility. Let's not lose sight of that, right? We're talking about the system.
Responsibility? What do you mean by that?
I think that litigants have a responsibility. Every time they call up their lawyer and say, file a motion, he didn't pay this month's public service bill and it's $200, and the lawyer says, well, that's going to cost you $1,000, litigants have a responsibility to make a decision as to what's a cost-effective way to proceed. So litigants have a responsibility, lawyers and the judge. That's the system, not just judges, not just lawyers.
That's making my point. Thank you. The problem is, in the adversarial system promotes that kind of a litigant who calls the attorney and says, make this motion, make this motion. They have to be disabused of that.
And I hate to agree with Pat because she doesn't need any help at all. But it does seem to me that she does make a point when she says, how do you take the emotional drama, the angst and the anxiety out of divorce?
You don't. There's always going to be emotional drama. But how long are we going to allow that to continue for? That's the issue. How long are we going to allow these people to use the system?
And that's where if you have a judge who takes control over a case, who imposes sanctions when somebody's using the system, who is in control of the calendar, who knows the family, who isn't the fifth judge in a case. The problem now is that sometimes the judge picks up the case, has no idea of the history, is the fourth or fifth judge, and it's frustrating for that judge as well as for the litigants and the lawyers. So if you have a judge who knows everybody from point A to Z, then that judge is more inclined to impose sanctions where somebody's abusing the system.
That would be nice, but that's an overrated concept. You have good judges. A judge is going to be able to pick up a file and pick up exactly where the last judge.
I wouldn't want somebody picking up my life, the fifth person down the line. I'll tell you that, and I don't expect it from my clients.
Does it happen often?
It happens enough. It happens enough, Ray. And again, it's not the judge's fault, it's just by virtue of how it's set up. Some counties are different. Some counties have a judge follow it from beginning to end. You know, there's been a system of rotation where judges have rotated through the court system, and we're hopeful and that we'll see less and less of that. We're hopeful that when you have a judge who wants to be on the family part, let he or she stay there. We're thrilled to have them when they're good.
Let me try to clear up a couple of misconceptions. A layperson reading the newspapers and who understands that both of you do seem to agree that time is money, and if you can shrink the time, you'll help, might think that this passage or this provision in the law that deals with 3 months versus 18 months might have something to do with that. I take you, tell us what that provision is. And
yeah, we do agree. There's a bill in the legislature which would permit people to get divorced if there are irreconcilable differences after a 3-month separation period. The way the law is now is you need an 18-month separation period to proceed on a no-fault basis, although in effect we're all no-fault in our state. All it says is that if you're separated for 3 months, you can just say we're not getting along, as opposed to saying he's sleeping with this one and he did that and she's bad and pointing the finger. From a lawyer's perspective, it just lessens the hostility. I think it's been misinterpreted by people.
Why won't it shrink the amount of time?
It's just a matter of time you file.
All that's going to let you do is file earlier, but the court...
You still got to wait?
Yeah, you got to wait until the other issues are resolved.
You can file tomorrow. Somebody comes into my office today, there's not a marriage, a happy marriage around that can't file on mental cruelty grounds. Anybody can come up with grounds to get divorced. The question is whether or not you hang in there and you see it through.
Now, there's another issue which I don't think the two of you disagree about, but I think is important to folks, and that has to do with the issue of paying college education down the road. What's that provision about, and why is there seem to be
There's a lot of activity in the legislature about stopping an obligation to pay college, when not having an obligation to pay college. And I think that lawyers in general recognize that it's appropriate to have some obligation by parents to pay college to the extent they're financially able. Not a mandatory obligation, but it's got to be a consideration. I think that generally lawyers agree.
Why is it generating controversy? The reasoning behind that bill, Ray, is that if you and your wife had an intact marriage and you just decided you didn't want to send your son or daughter to college, you don't have to do it. So why do you have a different obligation if you happen to be divorced? Well, divorced people act differently toward each other, unfortunately, and I agree with Pat.
Why is it generating public controversy?
Because I think that there are a lot of parents who feel that they shouldn't be obligated to do something in a divorce situation that they wouldn't be obligated to do if they were married. If they were married, they wouldn't have to send their kid to college.
Because as you may know, because I know you're loyal watchers of Due Process, we did a program a couple of weeks ago about so-called deadbeat dads, and the judge indicated in talking to some of our folks that, and talking to Sandy, I think that he got a fair amount of really strong anger and opposition from fathers who felt compelled that somehow tuition was being used as a weapon in an emotional war.
And, you know, it's an emotional issue, and I think sometimes fathers think that, well, if my child hasn't seen me or paid a lot of attention to me the last couple of years, why should I be paying for his or her college? They feel out of control, they feel forced, and you can understand their position and how they feel. But the reality is that the children are innocent victims no matter how old they are.
That's one of the standards of the case law say that the judge has to apply the relationship between the child and the father or the mother, and if judges would give that provision some teeth, that problem might be solved.
Let me get to another underlying issue, which is how often do you think children wind up being used as pawns in the emotional struggles between the divorcing adults?
I think that in every case with his children, to some extent, sometimes minor, sometimes major, one of the parents tries to use the children.
How often do you think that's a major factor, something that would disturb you as a parent or as a citizen if you're watching?
More often than it should be, Ray. And I think people are basically well-intentioned. I don't think people mean to hurt their children. If you looked at them, you know, and when they were more rational, said you're hurting your kid, they'd be shocked. But inevitably, the emotion spills over.
Let me go back to something Ed said. Then why wouldn't mediation be a kind of tool that might, at least in some percentage of cases, diffuse some of that anger? Because there are many folks who, if they saw what they were doing, might say, let me back off a little bit.
You're assuming that the mediation process is going to accomplish that, and I don't think that's so.
Is that the kind of a thing that
I don't think the mediation will accomplish that at all.
It's an old saying. It's like chicken soup. It couldn't hurt, really. And what's the downside of it?
The downside is you have somebody...
The system has to be improved somehow, and that's the way I look at it.
Let me ask you this. My experience from talking to ordinary citizens, and I think to some extent it's reflected in the report we showed at the beginning of the show, is a lot of folks don't have confidence in the system of divorce. I mean, a lot of women feel that women generically get treated unfairly. It's hard to find a man who doesn't think men get taken to the cleaners all the time. Why is there such lack of confidence, and quickly, can anything be done to address that issue?
I don't think so. I think it's such an emotional issue, and then it becomes a gender thing. I think we're always going to have that. I think the best thing we can do for these people is to get them out of the court system as quickly as possible, get them divorced, get their settlement into place, and let them get on with their
Well,
lives.
call me the eternal optimist, but I think things can be done. I think the Special Committee on Matrimonial Litigation is taking on a study, is something that's being done. I think the legislature is interested in reform. So I think these little changes are telling the public, hey, we are concerned and we're trying to improve the system.
What about the perception, and it's unfair for me to leave this to the end, that divorce lawyers are making a lot of money off the misery of people and just kind of churning? Is it a widespread perception in your view? Is it fair, and can it be addressed?
We're not the people who are choosing to be divorced. People come into our office, they are asking us to provide a service, and we're entitled to be paid for that service. I don't apologize for what I do.
Do you think that perception is out there, that people feel?
Yeah, of course it is. I think that people naturally, when they're going through a time where they're angry and they're frustrated, understandably, there's going to be a target, and sometimes it's the divorce lawyer, sometimes appropriately, many times inappropriately, Ray.
And Ed, you've seen the same phenomenon?
Absolutely, all the time, Ray.
Well, we hope that you'll bring about some changes just by being here with us at Due Process.
Thanks for having us,
Pat
Ray.
Barbrito, thanks
Appreciate
for being with us. And that's it for this edition of Due Process. But we'll be back next week with an encore presentation and another dimension in the legal wars between the sexes, sexual harassment, next time. Till then, for Due Process, I'm Raymond Brown.
The worst thing that I have to decide on a daily basis is who gets the kids. When I have someone up here who's giving me test results, who's giving me background scores, who's giving me a third-party independent impression, it makes my job a lot easier. I can see the two people who are testifying, I can hear other witnesses, and then I have an expert. It gives me a whole field of information to pull from. When people just come up and say, I want the kids, nothing else, it's an awful call. I can't tell in 5, 10, 20 minutes who's the best parent. It's impossible.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.